Hey everyone, this is What It Is, a place where we talk about how immigration law affects everyone and why immigration is a good thing. I'm Michael Ruddle, immigration attorney and founder at Ruddle Law PC based in Torrance, California, where we practice immigration law in all 50 states. Today, we're going to answer the question, what is expedited removal? It's something that's been around in immigration law for a number of years, however, it's come back into the limelight recently. As of July 23rd, 2019, the policy of expedited removal has been expanded. So what expedited removal refers to is legal authority given to very low-level immigration officers who can deport or remove non-U.S. citizens from the United States, often without due process, meaning no right to an attorney, no right to a hearing before an immigration judge. In other words, that means that certain individuals could be denied their fair day in court, even though they might qualify for other legal relief that would allow them to remain in the U.S. Now, Immigration and Customs Enforcement, also known as ICE, has said that this new policy of expedited removal is primarily going to be used and implemented in criminal investigations and worksite raids. However, we as immigration attorneys know that that is not always the case. Generally, expedited removal can apply to anybody who is accused of being undocumented, having committed fraud, or accused of misrepresenting information to a government official, and is encountered or apprehended anywhere within the physical United States. And the individual must have been in the United States for 2 years or less in order to be subject to expedited removal. Now, what that means is that individuals who ICE believes is subject to expedited removal, those individuals under the new policy must be given a reasonable opportunity to present documentation to ICE officials to show that they've been in the U.S. for 2 years or more. However, the burden is on you, the individual being apprehended or the individual being detained, to show to the satisfaction of ICE that the documents you're presenting are true and genuine and that you have been in fact been in the U.S. for 2 years or more. Now, immigration law is very complicated, as you know. Expedited removal is no different. But by law, expedited removal should not apply to U.S. citizens, not apply to lawful permanent residents or green card holders, and it should not apply to asylum seekers or refugees seeking to enter the U.S. at the border. It's very complicated, it has very severe legal consequences, and it's very difficult to challenge or fight back against an expedited removal order. If you have questions about whether you or a loved one are subject to expedited removal, contact an immigration attorney at Ruddle Law today to see if we can help you. Hopefully you found this video helpful. If you did, click that like button, hit that bell, subscribe to our YouTube channel if you haven't already, and follow us on Facebook to stay up to date on how immigration law affects everyone and why immigration is a good thing. Until next time, I'm Michael Ruddle. Keep climbing that mountain.